ratio that we haven't done that people would like to see. That's what I like. That's what I like to do.
Place to sit down.
Without any further ado, then, what I'd like to do is introduce the new president of the NJAA, Garrett Reed, Esquire, from Ehrlich, Petriello, Goodman Fleming. Garrett?
Well, I'd just like to clarify, it's the president of the POA, Property Owners Association. I am honored to be president. I've been a member for a long, long time. So this is a great, great organization. A lot of great education is given out here, and I'm just really, really happy to be a part of it. As Chris said, my name is Garrett Reed. I'm a partner with the firm of Ehrlich, Petriello, Goodman Plaza, as many of you know. Seated to my left, your right, is the Honorable Malin Fast, who is a judge of the Superior Court for 30 years, or close to 30 years. And he works with our firm now and is here tonight to impart some more knowledge on us, which is, again, really one of the benefits of this organization, education and the knowledge that comes up here to give information to our members. And I want to get into some information here tonight at the legal forum in a more formal setting, a more formal presentation to you, because it's a really serious issue that came up in early April where the U.S. Department of Housing and Urban Development put out a guidance memo, essentially changing the way owners must screen prospective applicants with a criminal history. It has literally changed how an owner must assess an application relative to criminal history. So, without further ado, I want to start off by briefly reviewing HUD's Office of General Counsel's April 4, 2016 guidance memorandum on the application of Fair Housing Act standards to the use of criminal records by providers of housing and real estate transactions, and that's the name of the memo, all of that. Which has imposed new standards in evaluating an applicant with a prior criminal history. This change is in part of the evolution of the Supreme Court's decision in Texas Department of Community Affairs versus Inclusive Communities. It was a U.S. Supreme Court case that came down in June 2015. It was a 5-4 decision, so a very close split, but nonetheless fell this way. And in that 5-4 decision, the Supreme Court held that the district court used the correct standard for evaluating a fair housing claim of discrimination based on disparate impact. And that's really the important aspect here of the Inclusive Communities case as it affects the changes with the FHA guidelines. Disparate impact is a seemingly non-discriminatory policy that has a negative impact on protected classes. In its guidance memo, HUD cites the Inclusive Communities decision by stating that, quote, a housing provider violates the Fair Housing Act when the provider's policy or practice has an unjustified discriminatory effect, even when the provider had no intent to discriminate, close quote. It further states that under this standard, a facially neutral policy or practice that has a discriminatory effect violates the Fair Housing Act if it is not supported by legally sufficient justification. HUD notes that, open quote, while having a criminal record is not a protected characteristic under the FHA, criminal history-based restrictions on housing opportunities violates the Act if, without justification, their burden falls more often on renters of other housing market participants of one race or national origin over another, close quote. The memo notes that African Americans and Hispanics are arrested, convicted, and incarcerated at rates disproportionate to their share of the general population. Therefore, imposing a blanket ban on any person with a criminal history has a disparate impact on those protected classes, and that triggers discriminatory effects liability for you. Now, remember, the Fair Housing Act applies to owners of rental property. The exclusions are for family owner-occupied properties. Otherwise, you fall under the purview of the Fair Housing Act in your rental practices. The Discriminatory effects liability is assessed under a three-step burden-shifting standard requiring a fact-specific analysis, and I highlight fact-specific analysis. Number one, evaluate whether the criminal history policy or practice has a discriminatory effect, and the burden to prove that is on the agency or person alleging the discrimination. So they have the initial burden to prove this. They must prove that the housing provider's criminal history policy has a disparate impact on a group or groups of protected classes. The memo notes African Americans and Hispanics. The burden is met by evidence proving that the challenged practice actually or predictably results in disparate impact. The agency or person alleging discrimination may use local, state, and likely national data to support this claim. HUD notes that regardless of the data, this step must be reviewed by a fact-specific, case-by-case inquiry. So, in order to prove this aspect, it's fairly simple. To show, using national statistics, that your criminal history policy is having a disparate impact on a protected class. And HUD gives us the numbers in this memo, saying that African Americans and Latinos in particular would be discriminated against by a blanket criminal history policy. Number two, in the three prongs, evaluate whether the challenged policy or practice is necessary to achieve a substantial, legitimate, and non-discriminatory interest, and the burden is on you, the housing provider, if we get to this prong. So in other words, if they meet the first prong, now the burden's on you to prove this. A housing provider must prove that the practice is justified. But HUD notes in its memo, this can't be hypothetical or speculative, saying that, well, because they were a criminal, they're going to be a dangerous person to other residents or to property. That's hypothetical. And that's not enough to meet your burden. There's a case pending right now in New York. It's called Fortune Society versus Sandcastle. Fortune Society is I believe, a nonprofit group that represents ex-convicts. And Sandcastle is a group of owners in New York. There's a pending lawsuit against New York housing providers for blanket policies excluding applicants with criminal history. So these housing providers have a blanket policy that said, if you have a criminal history, you're denied. And Fortune Society has sued them, and HUD in its memo mentions this case in particular. Housing providers in this case have asserted the protection of other residents as their property as the basis for their policy. However, in its guidance memo, HUD specifically points out that a housing provider must also have reliable evidence to show its policy actually assists in resident protection. Bald assertions that anyone with an arrest or conviction poses a greater risk does not meet this burden. 1. You cannot exclude because an applicant has prior arrests whatsoever. Should not even be a consideration. So if your rental policy right now takes into account prior arrests, get rid of it. Because if you use that as the basis to deny an application, you're in violation of the Fair Housing Act. HUD has all but come out and said that using prior arrests as a measure of denial or a factor of denial is not acceptable. If a housing provider imposes a policy that excludes certain applicants because of prior convictions, the housing provider must still be able to prove that such policy or practice is necessary, again, to achieve a substantial, legitimate, and non-discriminatory interest. A housing provider imposing a blanket policy will not be able to meet this burden. It must be a tailored policy. So if you have a blanket policy that says, if you've been convicted of manslaughter, we don't even consider your application, that's a blanket policy. You're not taking a case-by-case consideration, and that is likely going to be a violation of the Fair Housing Act. You have to look deeper. You have to have a tailored policy. Number 1, a tailored policy must take into account the nature and severity of an individual's conviction along with the amount of time that has passed since the criminal conduct. Now note, it's not since this person was released from prison. And I've read this memo several times. And several times HUD uses the words criminal conduct. That means it's the time that has passed since the actual criminal conduct has occurred. Not the date of release from prison. Number two, in sum, the